Hi, everybody. My name is Julia, and I run the Office of Off-Campus Living up here at Western. And I am with two of our peer advisors who work for the Office of Off-Campus Living as well. Do you guys want to introduce yourselves?
Yeah, hi, I'm Kendra.
Hi, I'm Ethan.
And so I thought I would just talk a little bit about Home Month. This event is part of Home Month, and Home Month stands for Helping Out with Moving Essentials, and Off-Campus Living has dedicated this month to helping you prepare to move off campus and then be a knowledgeable renter when you live off campus. So we have had several events in the past, but we have some more events coming up after this one. This coming Thursday, we'll have an event called Being a Great Neighbor, which is all about sort of the laws you need to know about once you move off campus, as well as home safety and preventing theft at your house or of your bike. And then we're going to be starting March with the housing fair, which will be an opportunity for students to come and talk to landlords virtually through chatting or through Zoom drop-in meetings, or you can watch videos of their properties. You can chat with them and directly email them if you want to, and just kind of get an idea of what sort of real estate is out there and how much it costs, and get an idea of what landlords you might like to rent from. And then after that, we're going to do our second roommate speed date, which will be Thursday the 9th, I believe. And that is just basically an opportunity for a bunch of people who need to find a roommate to come together and chat and talk in a kind of fast-paced speed date type format. So we hope that you come to those as well. And if there's any, if you ever have any questions or need some help with your move off campus, or need some advice on living off campus, we are here to help. We have office hours every Friday from 3 to 5 with Ethan. So reach out to him. You can get information on our website. If you Google www off campus living, will pop up. And we also have an online Canvas course, which is just a 20-minute crash course on a bunch of information you need to know about to start your rental search and your renting experience. So that can be kind of helpful. And then you can also just email us if you have any questions at offcampusliving@ww.edu. So with that being said, I'd like to welcome David to the meeting. David is from Law Advocates of Washington, and he's talking about really important things you need to know about landlord-tenant law, leases, deposits, and that sort of thing. So welcome, David.
Thank you. Thank you, Julia. It's really an honor. I really appreciate being invited. And as Julia and I discussed earlier, questions anytime is great. And if you put questions in the chat, Kendra has offered to, Kendra or Ethan, one of you, I don't remember which one, offered to keep an eye on that for me. So please ask questions anytime. So the topics for today are leases, deposits, and repairs, focusing on your rights as a tenant. That's our logo at the bottom. Law Advocates is the volunteer lawyer program for Whatcom County. So we basically connect people who can't afford an attorney with volunteer attorneys for consultations or occasionally some kind of legal assistance. That's our phone number there. If you want to connect with any of our programs, including our tenant clinic, you can call extension 15. You'll get a call back for an intake. And that's my extension there as well, extension 22. I am the staff attorney at Law Advocates. Briefly, some resources for Washington tenants. Of this list, probably the most useful is washingtonlawhelp.org. which is a website maintained by a statewide legal aid organization. It's ferociously updated with information about topics such as housing, family law matters, all kinds of things. And it will direct you to most of these other resources as well. You know, the internet is your friend. The other important resource is a hotline, which is very useful if you can get through, but it's a limited resource. So you do have to call early and often. The central statutes to be aware of if we're talking about tenant rights and landlord-tenant relations in residential situations is Chapter 59.18 of the Revised Code of Washington. If you Google that 5918 RCW, you should be taken right to the official site provided by the state of Washington. Looks like this. You see there the different sections. It's a truncated list. It goes on for about 500 sections. You can click, of course, on any of those sections and be taken to the text. It's pretty user-friendly. Of course, it's legalese. Some sections are easier to understand than others, but it's great to, if you can, delve into that and try to figure out for yourself what your question is. I'll just answer to your question. I'll just tell you that a trick that even lawyers do when they have no idea where to start in finding the law is to type RCW followed by your question. So RCW landlord's duties, RCW theft, RCW driving while impaired, RCW miniature horses. You're likely to hit the exact law for the state of Washington. Most of the laws we think of, criminal and civil, are part of the revised code. Here are a few high points I want to hit before we get started. These are myths that I hear about, something that landlords tell tenants are their duties that are not actually their duties. And so I just want to make sure I touch on these briefly and dispel these myths. Tenants do not have to agree to new terms in the middle of a lease. The whole point of a lease is that you've signed an agreement for as long as that lease is in effect, and those are the rules. The document you've signed are the rules of the lease. You can make an agreement with your landlord to make changes in the middle, but if you want to hold your landlord to that first agreement, that's the point of the contract. Also, tenants with leases are not required to move immediately if a landlord is selling the dwelling, because COVID has had an impact on landlords as well as tenants. Some landlords, particularly smaller ones, are considering month by month whether they have to sell their properties, and that does come up. The rule under the law is that the lease runs with the land. And since the lease runs with the land, if you are in the middle of a lease and your landlord wants to sell your dwelling, they can do that, but they have to disclose to a buyer that you have a lease. And once they disclose that to the buyer has to decide whether they want to buy you along with the property. If they purchase the property, they'll purchase the lease along with the property. Tenants also don't need the landlord's permission to break a lease and move out. They do not need the landlord's permission, but they do need to understand that by breaking a lease early, if they don't have the landlord's permission, they may end up paying the landlord a little money to basically meet their obligations and make the landlord whole. But we do occasionally meet folks who have been told by their landlord that they cannot move out without permission. Sometimes there's major life events or other situations where it's really better for the tenant to vacate early and take the financial consequences. You're free to do that. Finally, another one we hear about is tenants being told that they must find a replacement before they vacate. The same thing, if you break a lease and move out, maybe you're one of 3 or 4 roommates and you don't find your replacement before you move out, you may take a financial hit for doing that. You also might make life a little tougher for your roommates. And if those are your friends, you might feel bad about that. But you do not have a legal duty to find your replacement. And so sometimes you just have to weigh the financial consequences against the necessity or the burden of staying there after you want to leave. A lease is a contract. That's just a very important fundamental concept in the law. Whether a lease is written or unwritten, whether it's a handshake agreement or whether it's 30 pages long. If you have a rental agreement, it's a contract, and each party, the landlord and the tenants, have duties and they receive benefits. Obviously, fundamentally, in a residential lease, what the landlord has a duty to do is provide a living space, and the benefit to the landlord is they receive money. What the tenant has a duty to do is pay the money, and the benefit they receive is quiet enjoyment of that living space. The other key concept in terms of contract law is the legal concept of making someone whole. So if one party fails to perform per the agreement, it's understood that they have to somehow make the other party whole. Usually it comes down to somebody paying somebody else money because they didn't perform under the contract. I think it's important to always think of this step of signing a lease or moving into a residential dwelling and paying rent. Think of it as a business decision. Realize that your landlord cannot guilt you into making decisions you don't want to make or choices you don't want to make, but at the same time, you should be very careful to learn as much as you can about the situation you're getting into before you take that step. So please, please, please read your lease. Ideally, read your entire lease before you sign it. Sometimes leases are lengthy, but a court will regard your signature as proof that you read the lease and understood it and agreed to it, whether you actually did that or not. So it's really important to read your lease thoroughly. And if you have questions or concerns, raise those concerns. It's perfectly all right to scratch out language in a lease, make changes to it with handwriting, and initial those changes. If both parties agree to changes like that, the document is perfectly valid. This is one of the things we're there for as a tenant clinic. We cannot really have the resources to review a 30-page lease, but if you've read your lease and you have questions about certain paragraphs, we're happy to give you a consultation with a volunteer attorney to advise you on what that language means. A brief word about how long leases can last. Residential leases are different from commercial leases. If you're signing a written lease with especially with a major property manager like Windermere or Remax or one of the other big management companies in town, you're probably signing on for a certain term, like a year or 9 months. The benefit to the landlord is obvious, that they can sort of guarantee they're going to get income for those 9 months or that year. But that's the same benefit to the tenant, because again, you sort of lock in the terms of that lease. So if you like the lease you've signed, you've locked in those terms. Leases for over 1 year are frowned upon, and that's actually the legal term, frowned upon by the courts. They're permitted, but they're only permitted with unusual steps. For example, the lease, all the signatures on the lease would have to be notarized by a notary. And the reason for that is the courts realize, and the legislature realizes, that people signing residential leases usually aren't business people. So they may not understand all the terms, and leases for over a year may not be something they can really follow through on or meet their obligations on. And sometimes landlords are just as ill-equipped to understand legal language or legal fine points. There's a lot of landlords out there who own a second property or maybe a couple extra properties. You're using those to generate some income, but they're not professional landlords. Written or unwritten leases can also be what's casually called month to month. A lease that is not a term lease is just a lease that renews every time you pay the rent. So each time you pay the rent and the landlord accepts the rent, that is like a new contract for that term. It's very common for people to pay every month, and the landlord accepts the rent every month, and that assures tenancy for another month. Here's some of the situations where a tenant can find themselves in a month-to-month tenancy. If you don't have a written agreement regardless of what you understood from the landlord about how long you're going to be able to rent. Oral agreements are month-to-month agreements. If you have a written lease and it says it's month-to-month, that is also a month-to-month lease. If a lease is a lease for over a year, but it wasn't notarized, they didn't take those extra steps, the court is going to disregard the term in the lease and probably regard that as though it was for an unwritten term. So again, a month-to-month. And if you stay in your dwelling after that first year and that lease expires and you keep paying rent and the landlord keeps accepting it, you are now a month-to-month tenant. And one reason why that is important is because it's very easy to terminate a month-to-month tenancy. Now, right now, because of COVID, there's a governor's proclamation that prohibits most terminations, not just month-to-month leases, but most terminations of residential agreements, period. There's only a few situations in which someone can be thrown out by their landlord through the courts. But under the normal law, which we could see back in effect as early as April, either party can terminate a residential month-to-month lease with only 20 days notice. It has to be a notice in writing. It has to be a notice terminating at the end of a rental period, so not mid-month. But statewide, the law says the notice can be as little as 20 days, and that can certainly catch people off guard. Bellingham has an ordinance requiring 60 days notice for properties within the city limits. So that alone could be a consideration if you're weighing the benefits of two possible situations, and they're both month to month. Just the extra time that would be given to you if you're within the city limits is worth consideration. A few definitely bad ideas that I like to mention. One is being a subletter. So if you decide you need to vacate early and your landlord tells you that you can find your own replacement and that person will be subleasing under you, the reason your landlord wants you to do that is so they can hold you accountable for any damage done by that tenant after you're gone. There's no benefit to being a subletter, and you do not have to be a subletter. The one possible benefit is if you're leaving for a couple months and you intend to come back within the same year, but I think those situations are very rare. Again, you're not required to find your replacement, and the potential downside is huge. If you're no longer living in that residence, you don't know what is going on there. You're not just trusting the person you found to replace you, you're trusting their friends and their guests. One bad accident, which can happen to anyone, such as a kitchen fire, could leave you liable for tens of thousands of dollars in damages. Another thing I like to mention is a term in a lease that requires you to arbitrate your disputes. Arbitration is an important legal term, and it means you're going before a professional called an arbitrator who makes a decision, sort of like a judge, but it's not an inexpensive option like the courts. So unfortunately, if you agree to arbitration, excuse me, for matters of only a few $1,000s, those kinds of disputes, it probably isn't feasible to pay an arbitrator to handle the case. So if you've agreed that you're going to handle it through arbitration, you probably have no legal recourse at all. Two other things that sometimes make people raise their eyebrows when they see them on this list: paying a lot of rent up front or paying cash and not getting a receipt. I see these all the time, especially the second one. People who pay their landlord maybe $1,200 a month, they give the landlord cash and the landlord never gives them a receipt. And people tend to trust other people, but again, this is a business relationship. You need a receipt for that kind of money. You need it because you run the risk that you won't be able to prove that you paid the rent. Anything could happen to your landlord, or your landlord could have ill intent at some point and claim you haven't paid. Proof that you pulled $1,200 out of your bank account is not proof that you gave that $1,200 to your landlord, and people can really get in a pickle over that. The simple solution is to just write up your own receipt, date it, describe in a sentence who gave money to who and what it was for and how much, and have your landlord sign that. You give them the money, they give you the receipt, and you're covered. If your landlord doesn't even want to do that, no matter how informal they are, if they don't even want to do that, you know you're dealing with someone who's trying to hide things in their lives. And I'm not saying don't rent in that situation. I'm just saying be aware of the hazards. I may skip these topics and come back to them because I see that we're 20 minutes in already, and I know we want to get on to the other two topics today. So we'll see if we have time to come back to this. I'll just touch briefly on joint and several liability. That's a legal concept that means if several adults sign the same contract at the same time, they're agreeing that any party that is damaged can go after any of those signers or all of those signers. So for example, if the landlord claims after everyone moves out that there's $5,000 in damages to the apartment, and they can pick and choose who to go after for that $5,000. If there's 3 roommates, they could go after the person who was most responsible and gave them a forwarding address, and maybe that person's co-signers, parents or friends that signed for them. The landlord can choose to go for whoever has the deepest pockets, or they can choose to go after everybody. The best solution to that, if you can do it, is to sign your own copy of the lease. Just sign a separate lease agreement, even if you are in a roommate situation. Landlords discourage that because they would prefer to have joint and several liability. Some common questions, which I hope I've already answered. The first two. Can my landlord raise the rent in the middle of a lease? No, the landlord cannot. Why not? Because the lease makes the rules. It's a contract. You could agree to an increase. You can always modify that contract in the middle of the term, but you don't have to agree. Same thing with other rules, like maybe a sudden rule about visitors or a sudden new rule about using the laundry room. Can the landlord make up new rules in the middle of the lease? Also, no, they can't do that unilaterally by themselves. You could reach agreement on changed rules. You should sign off on that changed agreement, but your landlord can't impose those things in the middle of the lease because the lease is the contract makes the rules. Very common question is what happens when the lease ends, that question of the 13th month. And this is one example of where it's a really good idea to read your lease carefully. There's 3 kinds of leases in terms of the way they're written. A lease might say, let's say it's a 1-year lease. The lease might say that at the end of that year, it automatically renews as a month-to-month agreement. That means as a tenant, you can expect to continue paying for the 13th, 14th, 15th month. You can expect the landlord to accept that rent unless they've given you notice that they're not going to do that. Or a lease might say that after the year ends, the lease terminates. In that case, your expectation should be that if you want to stay past that first year, you should probably start talking to your landlord in the 9th or 10th month about renewing that lease so that agreement extends. Because at the end of that 12th month, when you tender your rent for the 13th month because you want to stay, your landlord may refuse to accept that rent and may say, no, I'm sorry, I need you out of there for whatever reason. They don't need to let you stay if the lease is ending. The third situation, which is fairly common, is that the lease doesn't say anything either way. And in that case, in most of those cases, the law supports the interpretation that the lease terminates. So it's just as though the language in the lease said it terminates. The tenant should be prepared to either renew the lease at the end of their first lease or to move. They got to be thinking about that decision as their first lease comes to an end. Any questions about leases before we go on to deposits? We have anything in the chat or anything like that? Okay.
There's nothing in the chat.
So let's go on to deposits. some types of deposits, and you see that I'm referencing the section of the Revised Code of Washington in some of these slides. It is appropriate, if they do it right, for a landlord to require a deposit to secure a rental unit before you move in. It is not legal for a landlord to require a deposit to get put on a waiting list for a possible unit. But if they have a specific unit available to rent, they don't have to show it to you. They just say, yes, this unit is available. If they accept your application and say, yes, we will rent this unit to you, but we need you to pay us money to secure your occupancy, to ensure that you are actually going to move in. They can demand at least a third, or sorry, they can demand up to a third of the monthly rent for that security. Once you are occupying the premises, they have to apply that to rent or other costs. It's not money that they pocket. And they do have to spell out the other conditions on which they would keep the money. For example, if you changed your mind, but there's no reason beyond the fact that you just found someplace else and they didn't do anything wrong, they may keep that deposit. That's kind of the point of that deposit. Sometimes you'll see the term non-refundable deposit in a lease. A non-refundable deposit is just a fee. So very common one is for something like carpet cleaning. They'll say we're taking a $1,200 damage deposit and $300 of that is non-refundable for carpet cleaning. It's not really a deposit, but they call it a deposit. Just realize that non-refundable means exactly that. Pet deposits, very common to see pet deposits as part of a lease. Sometimes they are non-refundable, so they're basically a pet fee. None of these deposits are legal if the animal is an assistive animal under federal law. So that's protection under the Fair Housing Act. If your animal is an assistive animal or a guide dog or something like that, in other words, medically recommended, and you have that animal for your health benefit, they're not a pet. And the landlord cannot create any barriers to having that animal, including charging you any extra fees. Damage deposit is the most common, and last month's rent. Almost every rental situation has those two. The law says that last month's rent is only supposed to be used for last month's rent. You may get some resistance from your landlord as the 12th month approaches on your lease or the last month approaches on your lease. And if you're continuing to rent past the first term and you're signing a new lease, you can expect to not apply that rent or to just have it stay in your landlord's pocket as long as you continue to rent. Damage deposits and those other deposits are supposed to be held in what's called a trust account. It's not supposed to be your landlord's normal business account. They're supposed to keep it separate, and they're supposed to tell you where they're holding that deposit, what bank it's in. That's in case there's a sudden change of ownership or management, so that you know where that money is if you need to go after it. A few words about damage deposits and how to get it back. The idea of a damage deposit is that you as a tenant are supposed to return the apartment or return the house to the landlord at the end of the lease in just as good a condition as it was when you got it, with the exception of what's called wear and tear. So the law understands that if you live in a place for 6 months or a year or 2 years or 5 years, gradually there'll be an increasing amount of small damage accruing, such as carpet wear, such as walls that no longer appear freshly painted but are starting to get smudged or a little bit dirty, those kinds of things. In Washington State, there's not a lot of definition, legal definition to what wear and tear is. So that can lead to some disputes, but it's generally understood to be small things like that. Smudges on the wall, probably wear and tear, especially if you've been in there for, a year or more. Holes in the wall, especially something the size of somebody's fist or a beer bottle, not wear and tear. It's kind of a common sense understanding. If you're hoping to maximize your damage deposit refund, you should plan ahead starting right at the time you move in. Take lots of pictures, take lots of notes. Your landlord is not allowed to hold a damage deposit unless they are also completing a checklist with you, a detailed checklist on the condition of the property, and that is signed by both parties. So if your landlord ignores that step, it's their problem. They cannot hold a damage deposit if they don't take that step. Of course, landlords don't like to hear that, especially the ones who are not professional landlords, but might be informally renting a room in their house or informally renting a second property or an upstairs in their house or something like that. But technically those deposits are wrongfully held and you could demand it back at any time just because that checklist wasn't completed. The more notes you take and the more information you have about the condition on move-in, the better for you. Because when you move out, you want to be able to demonstrate that the damage that's there when you moved out was also there when you moved in. When you move out, your landlord has a 21-day deadline under statute to evaluate the damage and send you a written notice and a check. If they're going to pay you something back, they have to pay you that amount within that 21 days. They have to tender it in the mail. If they're not giving you everything back, they need to detail why they're not giving you everything back. And this is what starts the negotiation for a refund. Many tenants find they're not satisfied with that first notice from the landlord. If the landlord fails to meet the deadline, they're not allowed to take anything out of that deposit, and the law says they have to return it in full. But frequently, especially the larger management companies, are very, very good about meeting this deadline, but they're also very creative in terms of how much money they're going to take out of your damage deposit. One example of many is fire alarms, smoke alarms. So the law says that landlords have to provide the smoke alarms, tenants have to maintain them. Kind of makes sense. The landlord's not there every day or every week. And the tenant might be the person who took the battery out of that smoke alarm because the birthday cake got out of hand and the alarm went off, so they pulled the battery for a few minutes. So it makes sense that it's the tenant's duty to put that battery back in. But some landlords will charge $200 if they find an expired battery in a smoke detector on move out. So one of the steps you could take is take those pictures of each smoke detector in the house with that brand new fresh AA battery in it and save yourself a couple $100. All this kind of advice, again, is available through Washington Law Help. It's an excellent website for this kind of information. If you find that you are in a dispute with your landlord, your former landlord, about your damage deposit, that's a negotiation that can go on and on. You're going to get that letter, or you should, from your landlord that spells out why they're not paying you your full deposit back. I would recommend that you respond in kind, that you write what is called a demand letter back to your landlord and put as much detail in that letter as you can. Exactly what you disagree with, line by line. Well, you're charging me $530 for house cleaning. It's a studio apartment. It should not have taken that much time to clean. I feel $100 is fair for cleaning. You charged me $40 for a broken blind in the bedroom, but that broken blind was broken when I moved in. See my attached photo. You should credit me that $40, so forth. So you're taking the time to explain to the landlord exactly what your position is. At the end of it, you do the math and say, instead of taking my whole deposit and charging me an extra $700, I think you should give me, $950 of my $1,200 deposit back. If you write a formal letter and you mail that, you're setting yourself up successfully to demonstrate to a court that you've been reasonable And if your landlord is ignoring that, or they're not coming around, if you do eventually take them to small claims court, you can show the court possibly that they have been intentionally withholding your deposit. Essentially, they knew better than to withhold your deposit and they did it anyway. And the court could penalize them for that and end up putting more money than your deposit in your pocket for your time and trouble in getting it back. So let's move on to repairs. A landlord has a duty under the Revised Code of Washington to maintain the dwelling so it's fit for human habitation. There's a long list of specific provisions. There's at least 12 provisions in that statute of specific examples of what that means. For example, keeping the structure weathertight, maintaining the utilities and the appliances. So your plumbing goes on the fritz or your electricity goes on the fritz, it's your landlord's duty to restore that. If an appliance breaks, it's your landlord's duty to restore that. I get a lot of questions about things like garbage disposals or dishwashers, because sometimes those minor appliances or conveniences break down. Washing machines break down all the time, and the landlord says, well, you know, that's tough, I'm sorry. I don't have the money to repair your washing machine. Key question again is, what does it say in your lease? Read your lease, know your lease ahead of time. If that washer and dryer are mentioned in the lease, then your landlord has a duty to repair that washing machine. And if it's not mentioned in your lease, then it might be reasonable for your landlord to say, well, you know, that washer was there as a convenience, but it wasn't part of the rental rate, wasn't part of the agreement. So what does this mean? It again means that it's ideal if you can read that lease at the beginning, note the appliances that you actually saw when you toured the unit and say, hey, you know, I don't see the dishwasher mentioned in this lease. Can we write that in since the unit has a dishwasher? And then at least you'll find out how your landlord actually feels about that dishwasher.
Hey, David.
Yes.
We have a question about the writing a letter to your landlord. Someone is asking, would an email be sufficient, or is this something that should really be in physical letter form?
Great question. Really great question. The law has not kept up with electronic communication. I have a slide I hope I'll get to that talks about different levels of communication and what's best. Briefly, though, the problem with email is that you might send your landlord an email and then your landlord either ignores it or calls you up on the phone to talk about that email. If your landlord responds to your email and you can see a thread of emails, that's pretty good. I think that would be admissible in court. You should always be thinking what you're going to show a judge if you end up in court. That's pretty good proof that you communicated that email. Your landlord received the communication. But if your landlord ignores that email or they don't respond with an email, it can be hard to prove that they received that email. And that's the problem with email. So the gold standard under the law is an old-fashioned letter, actually dated, signed, stamped, and sent certified mail. That's a special way to mail, which costs a couple bucks extra for your letter. But the benefit is you have proof through the post office website of delivery of that letter. That's the gold standard for proving communication. There's nothing wrong with email, but you just have to keep in mind that you may have difficulty proving you communicated. When is it not the landlord's duty to make repairs? Well, a classic example is where the landlord claims that the tenant caused the problem. It is not the landlord's duty to repair defects that are caused by the conduct of the tenant or their guests, etc. So a classic example in this area is frozen pipes. This is not apt to happen in apartments, but it's a common problem in houses. You get an outdoor temperature down in the teens or the low 20s. If you're in an older house and you're maintaining your heat fairly low, or the crawl space is not well insulated, you might find your pipes freeze solid. If they're old copper pipes, those pipes are burst as soon as they freeze. It's an expensive repair. And you may find that your landlord says it's your fault. You did not properly maintain the pipes, so I don't have a duty to make that repair. Well, what's going to happen in that situation? In most cases, what's going to happen is the landlord will repair the pipes. The reason they're going to do that is because they own the property, they care about the property, and the property isn't rentable if there's no water, but they will probably claim that it's your duty to make that, to pay for that repair. So some landlords will include a page in their lease or a paragraph in their lease that explains exactly how to handle the pipes. If it's an older house, it may stay right there in the lease that you're supposed to leave the water running a little bit in the wintertime. That is a common way to address frozen pipes in this area, because if water is running through the pipe, it's much less likely to freeze solid. And it could increase your water bill. So again, know what's in your lease. Frozen pipes are just one example. The question of who is at fault can come down to, it can be controversial, it can be a dispute, and it may not be easily settled. Another example is a kitchen fire. Well, what were the circumstances of the kitchen fire? Was the stovetop behaving normally, or was it defective? I have seen situations where a tenant's stove stops shutting off. They will turn the burner to off and the burner will not shut off. That's a defect. That's not behavior of the tenant. That's a very dangerous defect which the landlord needs to address. I don't understand how you can design a stove that will become defective in that way, but I have seen it. And obviously, if there's a fire in that situation, then that's not the tenant's fault, and the landlord is responsible for the damages, not the tenant. If you have a defect arise during your tenancy and you need the landlord to make repairs, it's important to have a feel for the deadline your landlord faces. So generally, the landlord, after receiving written notice of the repair, has to start the repair 10 days or less after written notice, and they have to complete the repair promptly. That's what the law says. If it's a serious defect, for example, if it deprives the tenant of a stove and oven, or deprives the tenant of a refrigerator, or deprives the tenant of another major appliance, there's a 72-hour deadline. If it's affecting hot water, cold water, or electricity to the unit, I think heat is also on that list, or it's what the law says, hazardous to life. So again, depending on the facts, it might be an unusual repair situation that's hazardous to life. Then the landlord has only 24 hours to start repairs. But that duty, again, is triggered by written notice. Written notice is the standard under the law. So let's talk about portals, which are becoming increasingly common. You may find that your landlord prefers that you communicate all your repair requests through a portal. That's fine. It makes sense. Their business model is efficient that way. They can view everything through the software and address problems through the software. But you want to make sure you can prove you communicated, that you made written notice of the needed repair. If there's a way you can screenshot that notice that you gave through the portal that shows it was submitted, shows what time it's submitted, you can take a screenshot of that and protect yourself, great. But there are some portals where your message to the landlord just kind of disappears into the ether. In a situation like that, probably isn't a bad idea, if it's an important repair, to also write a letter to your landlord and send it through the mail. That again is proof that you've given written notice. There are a variety of remedies for the tenant if the landlord doesn't commence work on time, or if the landlord's essentially refusing or ignoring the repair request. But all of these are challenging. And again, most of these have to do with habitability. Is the apartment or is the house still fit for human habitation, even with this repair. If it's something minor, so for example, the door on the fridge is loose, or there's an unsightly water stain that appeared on a wall, but it doesn't affect the health or safety of the unit, that can be an annoyance, and you might have a long dispute with your landlord, depending on the landlord trying to persuade them to come out and do something about those problems. But if it's a serious defect that affects habitability, whether the apartment is fit for human habitation, then you have some remedies under the law. You could terminate the lease and move out. So if you let your landlord know that you moved out because you gave them the written notice of the major defect and they didn't fix it, and you said, I'm sorry, I had no choice, I had to move out, I have moved out, and under the law, I don't owe you any more rent, we're done. You have the right to do that. Again, there could be a debate on whether the defect was that serious or whether the landlord received proper notice of the defect. So you want to cover your bases before you take that step. There is also a process for withholding rent. Most of these laws, if you haven't already gotten the picture, are very specific to Washington state. Different states have different rules, and this is a key issue because some states, particularly like California and other states with many laws protecting tenants, are more liberal in this area. But in Washington state, if you want to withhold rent for making repairs, there's a complex dance you have to go through. It's kind of a 3-step communication process before you can withhold rent for a repair. It's all laid out in RCW 5918-100, and I can talk about it in detail, but you just have to be really careful. What you cannot do is simply send your landlord a letter that says, hey, you'll notice April rent is light by $230. That's because I had to pay somebody to come out and repair that window that you wouldn't fix. That's not legal. Your landlord can claim that that rent is past due, and you can be terminated for that past due rent. You can also, under the revised Code of Washington, you can sue for reduced rental value. So you could ask a court to find that repairs are needed, that they haven't been made, and so you shouldn't be paying as much rent, and the court can make that finding, make that ruling, and then basically that gives you leverage to convince your landlord to come out and address those issues because they can't collect their full rent until they fix things. I will say that this law has been on the books as long as I've been an attorney. I have asked around with other housing attorneys to see if anyone's ever been aware of anyone suing successfully under the statute. I haven't found anybody yet. It's probably happened, but it's not common because, of course, suing your landlord in the middle of a lease is not good for the relationship and also is pretty complex and involved. So we are at 4:48. Do I have time for a couple more slides? Julia?
Yeah, I think maybe if we could keep it to like 5 minutes and we'll have like 7 minutes for questions. That
Okay,
works?
great. So this is my modes of communication slide. As I mentioned earlier, the gold standard is a signed, dated letter, an actual printed letter sent by certified mail. Why is that so great? Because the United States government certifies that letter was delivered. So that's proof to a court that you sent that letter and that your landlord received it. That is the nature of communication. It was sent and it was received. You might have heard of fax machines. Some businesses have fax numbers. A fax is also an excellent way to communicate. It's not free, but a fax, when you send it, is electronic communication with proof of delivery. If you want to fax a one-page letter to your landlord, you can go to FedEx Kinko's and they'll probably charge you $5 or $8 to send that fax. But when that fax goes through to the fax number that your landlord has on file, Kinko's hands you a slip of paper that it proves the communication took place. It says the fax transmission was successful. and it's fast. So if you're fortunate enough to have a landlord with fax number, that's a fast way to communicate and prove it. Email, very common way to communicate. Text messages, also very common way to communicate these days. I mentioned the shortcoming, which is your landlord may decide not to respond in kind. If they don't respond to the email or the text, then with an email or a text, then it's hard to prove that they actually received that communication. The downside of a text, in addition, is that it's kind of hard to present a text message to the court. Although people will print out screenshots, sometimes they look better than others, and judges will read those screenshots, but they can be frustrating for the court. Email is sometimes easier. Voicemail, even more difficult to describe to a court or display for a court what went on in a voicemail. And then, of course, people sometimes communicate in person, and those are the toughest to prove and the easiest situation for people to misunderstand each other. I recommend if an important conversation was verbal and you're trying to keep things friendly, you can still just send a follow-up email or text message and say, hey, thanks for talking just now. I understand that we agreed to A, B, C. For example, my understanding is you're going to have somebody out to look at that window next week. Is that right? If your landlord replies and says yes, then you've just proven communication, that verbal communication.
Hey,
David,
Go ahead.
oh, sorry. I'll read the question to you. We have a question in the chat about that. So if a landlord calls you to communicate something, can you ask them to put it in writing? And do they have to comply with that request?
I would say they don't have to comply with that request, but if they're professional, if they're acting professionally, they will comply with that request. That's not a bad idea, especially if things are getting challenging, communication is getting challenging or difficult. And I would just phrase that by saying, hey, I just want to make sure we're clear on exactly what you're asking for, exactly what you're telling us. Could you please put it in writing? Send me an email. That seems reasonable to me. I think this slide might be self-explanatory in that just kind of recaps how you're going to address written communication. You want to be clear about the problem. You also want to be clear about the solution. The most common defect that I see in demand letters is a demand letter that doesn't make a demand. Does a great job of describing what the problem is, but it doesn't propose any solution. You can be specific about what you think is fair, what you think the solution should be, then you're going to move that conversation ahead and hopefully reach some agreement with your landlord. There are plenty of great landlords in Whatcom County. As an attorney defending tenants, I just tend to see the tougher situations, the tenants who are struggling. But good communication is always helpful to both parties, even if everybody's acting in good faith. That's basically my presentation. If you do want to call and get a consultation through the tenant clinic, we can connect you with a volunteer attorney, or sometimes it's me. We can interpret legal documents. We can listen to whatever your situation is, advise you of your rights and your strategies. For people who have a difficulty writing things themselves, we might go so far as to help you draft a letter, or we would certainly critique or edit a letter to your landlord. And if you find yourself headed for court, we can give you advice on how to handle yourself in court. So again, I just want to say thank you for thinking of law advocates and inviting us to speak. Are there any more questions?
We just got another question in the chat. Also, if anyone else has a question, you can go ahead and unmute yourself and ask David, or continue putting it in the chat and I'll read it out to him. So the question we just got is, could you maybe touch on how cosigners affect a lease?
Right, so a cosigner is someone who is guaranteeing payment. They're not living in the unit, but they agree to be held responsible if the person they're co-signing for doesn't follow through. Very common for younger people, especially who maybe not have a rental history, to have a co-signer to help them secure that first rental situation. Sometimes it's a parent, sometimes it's a friend with a rental history who can sort of lend that credibility to the situation. But a co-signer is really on the hook financially. They're on the hook for the rent, and they're on the hook for any damages that the owner later alleges. By on the hook, I mean that it's just like that joint and several liability situation. The landlord can choose to go after mom and dad, or go after your helpful Uncle Larry because they think Uncle Larry's Uncle Larry's pockets are deeper than yours, or Uncle Larry's easier to find. So if you do have a co-signer and you find yourself in a dispute or possibly in a dispute with your landlord, you just want to keep your co-signer informed. And I think ideally, if you're making decisions about whether to go to court against your landlord or whether to dispute charges from your landlord, you want to make those with your co-signer so that you guys are on the same page. Those are my thoughts about co-signers.
We don't have any other questions in the chat right now. Does anyone else have another question for David?
Sorry, are co-signers always required, and if so, how many?
Co-signers are not required by state law. Some property managers will require them depending on the background of the tenant. Some people have a damaged rental history. Some people have no rental history. And it's up to the landlord what they offer. So they can choose to offer you a lease and say that given your situation, the way we evaluated your application, we're going to require a co-signer for you. What they are not allowed to do, obviously, is discriminate based on any protected class, such as your gender or your race. They are also not allowed by law to discriminate on your source of income. If you demonstrate income of $3,000 a month through a job, and your friend and the person you hope to make a roommate, that friend demonstrates $3,000 income based on a disability payment from the state of Washington or the federal government, your landlord's not allowed to require a co-signer for your friend and not require one for you. They're not allowed to discriminate against your friend because their income is from some unconventional or less desirable source in their eyes. Did that answer the question?
Yes, thank you very much.
So would you say, I think you briefly mentioned this, but for more like strategies for making sure you document things, like the advice to take pictures of the fire alarm batteries, that first website, would that be the place to go for those?
Yeah, Washington Law Help has some pretty good guides in both English and Spanish, and they have several guides, I think, that relate to getting your deposit back. Just think of documenting everything and move in. You know, it's not the most exciting thing to be doing when you're moving into a new unit, but it's good to take lots of pictures of everything that looks wrong. Scratched countertops, scratched cupboards, old stains on the walls or the ceilings, holes in the walls. You're going to be negotiating in a pretty tough rental market. Rents are high. So you're probably willing to put up with some imperfections in order for rent you can afford. But if you're making those trade-offs, you want to make sure you're not held responsible for the condition of the property. Common example is landlords who would very much like to, at some point, charge a tenant for the full cost of putting in new carpet. So they may have a different group of students come through an apartment every year for 6 or 8 years. And when that carpet starts to look really nasty, they may try to charge those last tenants for the full cost of replacing the carpet, especially if those tenants have co-signers. Those co-signers are are apt to pay just to avoid the dispute or avoid the problem. What's your best protection? Your best protection is to take careful note of the condition of that carpet. Have some note on that checklist where your landlord signs off and acknowledges that the carpet is not new or the carpet is due for replacement when you moved in. Did that answer the question?
Yeah, thank you so much.
David, if there are no other questions, would you mind just briefly talking about the moratorium, the eviction
Yes.
moratorium?
Yes, okay. This is complex and I could easily do 90 minutes just on the special protections. But here it is in a nutshell. Way back last March, when the state emergency was declared, Governor Inslee, among many other orders, signed a proclamation 20-19. That proclamation prohibited most terminations of residential living situations. Not even just tenancies, but it actually protects people who are, for example, guests of tenants. Those people could normally be removed through a notice to the tenant. Those folks are protected. People who might be living on land with permission in a tent or an RV, but never paid rent, those folks are protected too. Very broad protections. Those protections have been renewed every few months right up until now. The current version is 20-19.5. You can find it by Googling Governor's Proclamations in Washington. It's a lengthy proclamation, but what it comes down to is you are probably protected from termination, from being thrown out of your dwelling, unless one of three things is true. The landlord could allege that you're a risk to health or safety. If the landlord can credibly allege that you're a risk to health or safety, he can terminate you through the court eviction process. Also, under this proclamation, the landlord could declare that he's going to sell the property or that he is going to move in himself or herself and make it their own primary residence. If they declare one of those two things and they give you 60 days notice, then if you fail to vacate, you can also be taken to court and evicted under the governor's proclamation. Now, where it gets tricky is you may have heard of the CDC moratorium. The Center for Disease Control has a nationwide moratorium that also is in effect through the end of March. President Biden has indicated he would like to extend that till September, but I don't think he's done it yet. That protection is intended to be a floor anywhere in the country where there isn't already a better protection. So it's kind of to catch people who are falling through the legal cracks nationwide. What's interesting about the CDC proclamation, does not allow a landlord to terminate you for 60 days notice to occupy or 60 days notice to sell the property. There's several exceptions to the CDC moratorium, but they pretty much all come down to health and safety. So the question before the courts is, does that moratorium apply in Washington? I've gotten cases thrown out based on CDC, and some other attorneys have. Other attorneys around the state have failed. The court just made a different decision. So there is actually a case before the state Supreme Court to decide whether that moratorium applies. It's a complex question right now. This is just one more reason. Anybody finds themselves in court or with questions about how the moratorium protects them, please ask us those questions. We're happy to answer those questions.
We have another question in the chat. This one's kind of long, so if you want me to repeat it, just let me know. So can you talk about the situation of someone moving into a property that already has people in it? Would you still want to take pictures and do a checklist, even though you're the only tenant, you're the only new tenant, and everyone else has already lived there for a full leasing period? And then after that, I'll ask you the second question after you ask that.
Okay, this is a great question because it's a very common situation. And unfortunately, the law is more or less silent on roommate situations. So you kind of gotta improvise based on what the law does say. And the simple answer is yes, I would still recommend composing that checklist just for your own records. Your landlord may go so far as to say, well, people are moving in and out, and that's all between you guys. I'll review the applications and approve the new roommate, but you guys have to pay each other your portions of the deposit as you move in and out, and it's out of my hands. They really cannot wash their hands of that obligation. If they originally took a deposit from 4 people, the landlord is supposed to, each time somebody moves out, evaluate the damage that they're going to hold back dollars for that person who moved out. And that becomes labor intensive for the landlord. So a lot of landlords don't bother to do it or don't want to do it. But you should, if you're moving into an existing situation like that, yes, I would recommend completing that checklist with your landlord if they will do it. And if not, maintaining your own records so that when you move out, you can say, hey, that beer bottle sized hole in the kitchen, that was in the kitchen wall, that was not me. Here's a picture the day I moved in. That beer bottle sized hole in the wall was there when I moved in.
And then the follow-up question to that one is just, what is your biggest piece of advice for someone moving into a property that already has people in it?
Well, it's not the ideal situation in most cases, just because, like I said, the law doesn't address that situation. It's going to be necessary for a lot of folks doing that. I moved into a situation like that when I was a Western student years ago. I mentioned to a friend that I wished I lived closer to campus, and he told me about a guy named Buck who had a bedroom opening up, and I met Buck, and Buck agreed to rent to me. And the other 3 of us paid Buck the rent, and we trusted that Buck was paying the rent to the landlord. And fortunately, he was. And Buck had been there the longest, so he was the alpha male and had the biggest bedroom. And one day, about a year later, somebody from the property management company showed up, and they didn't know Buck. They didn't know any of us. Nobody who was on the lease was living there anymore, and they were a little disturbed. But actually, that worked out fine because everyone was trustworthy and nobody was doing damage to the unit. What's the biggest piece of advice I have is just realize that you should trust but verify. To a point, it's natural and it's fine to trust that people are telling you the truth. But it's also good to verify. So for that one example, if somebody in the unit says, yeah, you pay me and I pay the landlord and I have permission to rent to you, before you move into that situation, it's good to know who owns the house, who's managing that house if somebody's managing it, what's the name of the company. They should be willing to tell you that. Then check with the company and say, hey, I'm moving into 124 West Street. I understand you manage that. Is that cool? Because you do not want to find yourself as an unauthorized tenant. You might be authorized by Buck, but if the management company doesn't know Buck, you could find yourself removed pretty quickly. I guess that's my biggest piece of advice in that situation.
We don't have any other questions in the chat. So are there any other lingering questions?
Yeah, I think I have one last question. I was wondering, what are some good things to ask your landlord to add to the property or appliance checklist when you're walking through the property with them, if you can do that?
To add to the checklist, let me bring up the language of regarding the checklist. That'll only take me a minute. So I'm looking up and reading RCW 59.18.260, and here's how it describes the checklist. A written checklist or statement specifically describing the condition and cleanliness of or existing damages to the premises and furnishings, including but not limited to walls, floors, countertops, carpets, drapes, furniture, and appliances. That's how it describes it. So as you can imagine, that could get time consuming. Some landlords will have a checklist that just says, write down the list, everything's fine, everything's in good condition, and they've just checked good condition on everything. If it's not in good condition, you want to snap a picture. That's probably the easiest way. Snap a picture and just, you can print those out and say, see photo number 6 or something. How far down the list you want to go, how detailed you want to get, just depends on how much you want to protect your deposit. You don't have to describe every scratch in the countertop, but if you notice that the kitchen countertops are scratched or marred, and you write right in there, you can write it right in there. You can say scratches and other damage to kitchen counters, and your landlord should sign off on that. I feel like I'm not really answering the question, but is that kind of what you're asking about?
Yeah, I just wasn't sure if you're allowed to write in different property or topics or anything like that. But yeah,
checklists take all kinds of shapes and sizes. Probably the most challenging thing people have is fitting the descriptions into the tiny little spaces on the checklist. So then you just say, see attached, and you just start a fresh page of paper that says living room, and you list all the damage in the living room. Kitchen, and you list all the damage in the kitchen. The more detail you put into that, the better protected you are when you want your deposit back.
Are there any last questions? Okay, sweet. I think we're good then.
It has really been a pleasure, and I have to say thank you for the engagement and the intelligent questions. It's nice to know folks are out there listening and thinking about this stuff. So.
Thank you, David, for coming and for helping spread this important information to our students. We appreciate it.
Thank you, Julia. Well,